Michael. If we're going to sit here and talk about the birthright citizenship, that means Barron Trump's got to go because he's an anchor baby.
Yeah, you know, when the same rules apply to them, they never wanted to apply to them. OK, so this is what we're dealing with now. Let's take a step back. This is all straight out of Project 2025. This is what we were warning people about. Roland, you and I and others here on the show, this is what we're warning people about, because this all deals with the fear of the browning of America. This deals with the fear that by the year 2043, white people will no longer be the majority population in this country. The 2020 census scared a lot of these white Republicans when the percentage population of white people in this country dropped below 60% for the first time since 1790, when the first census was taken. It dropped to 57%. Then you have Donald Trump saying the 14th Amendment was for the babies of slaves. Yes, it was the brainchild of Representative Thaddeus Stevens out of Pennsylvania, one of the radical Republicans. Yes, it built upon the Civil Rights Act of 1866. And yes, it was primarily Section 1, primarily for former slaves, but it was for former slaves, not just babies of slaves. I don't know what this fool is talking about. And then this also was came about 1868. It was ratified July 9th, 1868, when Louisiana and South Carolina ratified the 14th Amendment to the U.S. Constitution. One of the reasons why it came about was because of the Dred Scott decision, March 6, 1857, as your guest just talked about, where Chief Justice Taney, who wrote the majority decision, said that Negroes had no rights, that white people were bound to respect. He said they were not citizens, but also, just so people understand, the U.S. Supreme Court in that case also ruled that the Missouri Compromise of 1820 was unconstitutional because it robbed slave owners of their Fifth Amendment right to due process, and that nullified Dred Scott, whose real name was Sam Blow. It nullified part of his argument because he was taken into Illinois, which was a free state, and he went into Wisconsin, which was a territory. And the reason why Wisconsin was free territory was because of the Missouri Compromise of 1820. So this gets into a lot of law, gets into a lot of history, gets into the U.S. Constitution. But this is what we warned people was going to happen. Okay, we're seeing it unfold now, so we have to continue to fight. Lawsuits are being filed right now. Maryland and New Hampshire have announced they're filing class action lawsuits, as reported by the New York Times, against this. So this fight continues.
Two major Supreme Court rulings reshaping the legal landscape on reproductive rights and immigration. Millions of Americans could feel the effects immediately. In a 6-3 decision, the court ruled that states can block Planned Parenthood from receiving Medicaid funds, and not just for abortion, but for essential services like birth control, cancer screenings, and STD testing. In a separate decision, the justices sided with Donald Trump, pushed to limit nationwide injunctions, clearing the way for the administration to move forward with a plan to end birthright citizenship. A lot was said today. We're going to play you what Trump and the AG Pam Bondi said. We want to go right to our guest on this because, again, folks, it is unbelievable. Damon Hewitt, the president and executive director of the Lawyers Committee for Civil Rights Under Law, joins us right now. Samuel Spido, the associate director and counsel from the Legal Defense Fund. Glad to have both of you. Damon, walk us through here. People need to understand here. First of all, the Supreme Court did not overturn the citizenship issue, but explain to people exactly what did they do?
Well, the court halfway punted, but also did some damage today, and the story of the damage will only be told in the coming months and years as other cases proceed. The Supreme Court did not actually decide whether birthright citizenship should be preserved, punted on that issue. The court also didn't dig deeply into the 14th Amendment in a substantive way, which many of us feared, because I think that's a big political project on the right, to start undoing things like equal protection and what have you. But what the court did was it essentially did a process damage. It said, look, you can't actually do these nationwide injunctions. And that's a really big problem because, you know, it's essentially like telling folks, well, if you experience a harm, it's only individual to you. In a case that wins big for one person, they're saying it essentially doesn't matter for the next person who's in exactly the same circumstance under the exact same government policy. That is actually bonkers and is contrary to the interest of justice.
Samuel, the right had no problem with nationwide injunctions when Biden was president, especially related to student loans and other issues. In fact, Texas Attorney General Ken Paxton loved going to a particular judge, right-wing judge in Texas, to get those nationwide injunctions.
Yeah, very, I would say ironic, but perhaps not ironic. I mean, as Damon said, this is a real blow, and it is telling that this is the case that the Supreme Court decided to put this blow on our legal system. And one of the things I really wanted to lift up is Justice Jackson wrote a separate dissent. Justice Sotomayor had written the principal dissent. And what Justice Jackson said is, make no mistake about it, the court is dressing this up as sort of a legalistic, legalese type issue. But really the effect of this decision is to say that the judiciary cannot make sure the executive follows the law. Because as Damon said, yes, a court can say with respect to the parties before it, I'm going to rule in favor of certain parties. But the court can't then say, okay, well, you're somebody who didn't get to court. You don't have a lawyer. You don't have the resources to do that. We can't tell the executive branch to follow the law for you. And that is a tremendous, tremendous departure from basic principles of the rule of law and really quite dangerous for our democracy.
You also had a particular case, Damon, that dealt with religious rights where they are allowing parents to say, hey, I don't want my child listening to LGBTQ storybooks or things along those lines. What could be LGBTQ today literally could be Black History tomorrow.
Exactly. It's this so-called opt-out, this whole, we believe, manufactured parents' rights movement, Moms for Liberty, that type of stuff. What we're searching for, which is not readily apparent, is what is the limiting principle? Like you said, Roland, where does it stop? This is essentially taking private discrimination, at least potential private discrimination, and having the government or forcing schools to endorse it. It is actually going to likely either do one or two things. It will throw school districts and individual schools and classrooms into chaos, trying to navigate around people's private biases, or it's going to just water down curriculum, period. So it's going to be, test and drill and kill, just whatever's on the very basic curriculum. That's not good for anybody, including the students whose parents are forcing them to opt out.
Well, I mean, here's a perfect example. University of Alabama, Birmingham had a private scholarship, privately funded scholarship for Black medical students, and they stopped it because of threats from the Trump administration, their attacks on DEI. What we are seeing is they will apply this stuff to any number of things. And so if these parents, Samuel, are using this religious exemption or religious reason, they could slap that on anything.
Yeah, I think one of the through lines from the decisions that we have seen, and you mentioned at the beginning, the decision with respect to access for folks on Medicaid to be able to go to Planned Parenthood as part of the sort of defund Planned Parenthood movement, is a real sort of picking and choosing about who in our country is able to have the protections of the law, who is able to have legal rights enforced and who is not. And the Supreme Court has issued these very, very series of troubling decisions about who is really protected by the rule of law in our country today.
That you spoke of that Planned Parenthood decision. I mean, listen, they do more than just provide abortion services. We're now talking about millions of people who don't have access to health services. You have the closing of, it's not like, for the longest, I think back to the 70s, early 80s, you had community centers that provided services. Those things have long shut down. And so, what next if these states, especially red states, will be targeting Planned Parenthood, Damon?
Well, look, again, the question is, what does this all stop? There's been some success when it comes to the so-called big, beautiful bill, what our Sam and our friends at the Legal Defense Fund call the big billionaire bonanza, and it really is that, or the kneecap America bill, as some of us call it. We have to stop at the pass all these efforts to erode, undermine, eviscerate both civil rights and social safety net. I think, though, Roland, to going forward, what some of these moves are going to do, the Supreme Court decisions, other things happening on Capitol Hill, certainly what's happening in the White House, they are actually expanding our coalition. We know that Black communities are canaries in the coal mine. When we get a cold, when folks get a cold, Black America gets the flu. People understand that we are essentially been in a laboratory or being treated like we're in a laboratory when it comes to all these changes, all these erosions of rights. But more and more Americans are starting to feel it. Women are feeling it with the Dobbs decision overturning Roe v. Wade. This Planned Parenthood piece is going to hurt people not just on reproductive rights, but just basic health care. And if rural hospitals start to close, including in Appalachia, including in majority white counties in some of these states, more and more people are going to start to feel the pain, but they're starting to wake up. And so it's going to expand the coalition of people who are willing to fight back, push back through political voice at the ballot box and beyond.
Samuel, look, we keep telling people elections have consequences. Republicans, hard right, they've got a 6-3 majority on the Supreme Court. And one of the things we see is how these folks, they are attacking Justice Ketanji Brown Jackson, calling her a DE hire, all sort of stuff along those lines. They don't want any pushback. And what people have to understand is that this is a court that clearly says we're going to let Donald Trump do a hell of a lot what he wants to do. People have to recognize that you're moving closer and closer to the executive branch snatching tons of power from judicial, from legislative, and being as close as we've ever had to having a king.
Yeah, and so that's exactly what Justice Jackson said and really so powerfully explained in her dissenting opinion in the Birthright Citizenship case today. And I think one other thing that is really important to sort of pick up on one of the points that Damon was making is to remember what the history here of the Birthright Citizenship Clause is. It was understood from time immemorial in England and the United States that anyone who was born in the country was a citizen. And then in the most notorious Supreme Court decision of ever, the Dred Scott decision, the Supreme Court held that that did not apply to enslaved Black Americans. And so the Birthright Citizenship Clause in the 14th Amendment corrected that horrific decision and held that and made clear that everyone born in the United States is a citizen. So it is that magnitude of a constitutional right that today the Supreme Court has held there are real limitations on the ability of district courts to enforce. Yeah, go ahead, sorry, Damon.
Well, I just want to add, like, in the crux of the decision, the money phrase, of course, as we all know, is that there are no right. Negro has no rights which white man is bound to respect. So when we see these attacks, as you're talking about, Sam, on key core bedrock constitutional provisions, you got to wonder, are they reviving that mythology, that notion that there are no rights, that we have no rights, which are bound to be respected? So it is a dangerous, dangerous path, but these folks on the other side know exactly what they're doing. But we do too. All
right, then. Gentlemen, I appreciate it. Keep up the legal battles. Thanks a lot.
Of course.
Thank you.
Folks, going to go to a break. We come back. We'll chat with our panel about this here. We'll talk with them about a whole lot of other stuff. It is a wild, wild day. All right, folks, let's welcome our panel to the show. Matt Manning, civil rights attorney, joining us out of Corpus Christi, Texas. Michael Imhotep, host of the African History Network show, joining us out of Detroit. I'll actually be in Detroit this Sunday for the NAACP Freedom Fund dinner, so picking up an award there. Also, Eugene Craig, CEO, X Factor Media, out of Baltimore. Matt, I'll start with you. Look, this is a right-wing court. They are lovers of religious liberty. They will side with these right-wing folks as much as they can. That's pretty much what that LGBTQ religious rights decision is. But when you look at this whole issue, the right absolutely wants to get rid of birthright citizenship. And in fact, listen to the crap Trump said from the White House podium today.
The Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers. It was a grave threat to democracy, frankly, and instead of merely ruling on the immediate cases before them, these judges have attempted to dictate the law for the entire nation. Thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship, which now comes to the fore. That was meant for the babies of slaves. It wasn't meant for people trying to scam the system and come into the country on a vacation. This was, in fact, it was the same date, the exact same date, the end of the Civil War. It was meant for the babies of slaves, and it's so clean and so obvious. But this lets us go there and finally win that case, because hundreds of thousands of people are pouring into our country under birthright citizenship, and it wasn't meant for that reason. It was meant for the babies of slaves. So thanks to this decision, we can now promptly file to proceed with these numerous policies and those that have been wrongly enjoined on a nationwide basis, including birthright citizenship, ending sanctuary city funding, suspending refugee resettlement, freezing unnecessary funding, stopping federal taxpayers from paying for transgender surgeries, and numerous other priorities of the American people.
All right, Matt, thoughts?
So I'm going to address the religious liberty thing first and say I'm actually going to take the opposite tack. I don't know how we can live in a country where we talk about not having an establishment clause or not having, having the free exercise of religion and then say that people cannot opt out. I think it becomes a bigger issue if the Supreme Court in subsequent cases says that a public school is now required to provide a religious class for those who opt out. And I understand all the policy arguments on it, but I also believe very strongly in religious freedom. So I don't actually have an issue with that case. I get where it comes from. I think that there are some policy issues that could cascade out of that. But I think if we're going to honor the First Amendment, we have to do that. So I actually don't have an issue with that decision. However, as it relates to the birthright citizenship, I have a big issue with that one because this court decides to be textualist and follow exactly what it says when it wants, and then it allows the president to have unprecedented expansion of executive power. But here's the long and short of it. I lost a case today in Houston. I lost a case where morally I could not be more right. But I lost it because my client lives in Texas in the Fifth Circuit. If she lived in Pennsylvania, she would have been able to bring the claim that I brought. I specifically asked the court to extend to her the same ability to bring the claim that she would have if she lived in a different state that she does not have because she lives here in Texas. The reason I tell you that is this. That is the real crux of this case and the crux of this whole issue. We live in a country that is super federalized. We know what's happening. I'm talking to you. You're in D.C., I'm in Texas, Michael's in Michigan, and the brother Eugene is in Baltimore. That is not something that existed in terms of technological ability when this country was founded. I tell you that to say we have a legal fiction that we continue to perpetuate in terms of, states' rights and in terms of you have a different, basket of rights living in one place as opposed to somewhere else. Nationwide injunctions are kind of an outcropping of that. The idea that a judge one place could stop the executive across the board is what the Supreme Court bought on. But the reason that's stupid is because the people who are affected by that same policy in Maryland or in Michigan or in Texas, a judge should be able to make a competent ruling that affects all of those people because the harm to those people is universal. So the legal fiction that exists here is the idea that, what we all know to be true, that a judge who's listening to it, who makes a decision when there's all these people who are similarly situated does not apply because it didn't apply in, 18th century England is bogus. But that's the legal fiction that we deal with. That's the legal fiction I deal with every day. And I don't know how we resolve that until we as a country are honest about the fact that we live in a country where everything is, simultaneously viewed. We see what happens across the country, across the world in real time. So it no longer really exists to say that what happens to a person in Pennsylvania should be governed by different rights and different rules than what happens to a person in Texas. And I think that's the fundamental tension that we're seeing here. And I don't know how that will be resolved until our Constitution has an amendment or until we start to have a more expansive interpretation of the Constitution and the laws as they apply.
Eugene, very simple. They don't want that to happen. They want how issues are being decided in the Fifth Circuit to be the case for the entire nation. That's what they want. Eugene, if you don't fix that damn mute button, I'm gonna whoop your ass.
I'm a serial muter.
You are worse than Nola with that damn mute button. Come on, man.
Hey, nothing on the homie. But the thing is this, right? That's what they want, but I think also they don't understand the can of worms that they was talking about, right? Okay, if injunctions aren't going to be nationwide, are they going to be just specific to the state or to the district that the judge resides in? Now you're going to have civil suits, class actions all over the place. And then on top of that, the next time you have a Democrat president and whatnot,
actually, hold on, Eugene. I'm gonna stop you there. For some reason, your audio is actually distorted. So y'all work with Eugene on that. Michael, if we're gonna sit here and talk about the birthright citizenship, that means Barron Trump's got to go because he's an anchor baby.
Yeah, when the same rules apply to them, they never wanted to apply to them. Okay, so this is what we're dealing with now. Let's take a step back. This is all straight out of Project 2025. This is what we were warning people about. Roland, you and I and others here on the show, this is what we're warning people about, because this all deals with the fear of the browning of America. This deals with the fear that by the year 2043, white people will no longer be the majority population in this country. The 2020 census scared a lot of these white Republicans when the percentage population of white people in this country dropped below 60% for the first time since 1790, when the first census was taken. It dropped to 57%. Then you have Donald Trump saying the 14th Amendment was for the babies of slaves. Yes, it was the brainchild of Representative Thaddeus Stevens out of Pennsylvania, one of the radical Republicans. Yes, it built upon the Civil Rights Act of 1866. And yes, it was primarily Section 1, primarily for former slaves, but it was for former slaves, not just babies of slaves. I don't know what this fool is talking about. And then this also came about 1868. It was ratified July 9th, 1868, when Louisiana and South Carolina ratified the 14th Amendment to the U.S. Constitution. One of the reasons why it came about was because of the Dred Scott decision, March 6, 1857, as your guest just talked about, where Chief Justice Taney, who wrote the majority decision, said that Negroes had no rights, that white people were bound to respect. He said they were not citizens, but also, just so people understand, the U.S. Supreme Court in that case also ruled that the Missouri Compromise of 1820 was unconstitutional because it robbed slave owners of their Fifth Amendment right to due process, and that nullified Dred Scott, whose real name was Sam Blow. It nullified part of his argument because he was taken into Illinois, which was a free state, and he went into Wisconsin, which was a territory. And the reason why Wisconsin was free territory was because of the Missouri Compromise of 1820. So this gets into a lot of law, gets into a lot of history, gets into the U.S. Constitution. But this is what we warned people was going to happen. Okay, we're seeing it unfold now, so we have to continue to fight. Lawsuits are being filed right now. Maryland and New Hampshire have announced they're filing class action lawsuits, as reported by the New York Times, against this. So this fight continues.
Hopefully is everything straight with Eugene? We got Eugene back. Eugene, can you hear me?
Oh, wait, hold on.
All right, there we go. All right, we seem to be better. There we go. All right, then. Now you can make your points.
I was just going to say that, they should be prepared for everything that comes with class action lawsuits across the country, flying all over this country. And then on top of that, when you end up with President Harris in 2028, going to 2029, Republicans have been probably the bigger abusers of nationwide injustice, Democrats. We saw it with everything that was Obamacare, DACA, the student loan forgiveness, you name Democrat priority here. Come next go around, they won't have that tool in their toolbox, and class action lawsuits move much more slower than an actual civil injunction does. But good luck, Republicans.
Well, what I would hope happens here is that this wakes folk the hell up and realize that when you sit elections out, when you complain about things, but then you don't vote and you don't maximize your vote, then you see what happens. And so, people need to realize that this thing is real. We warned folks about this, and now they're seeing the real effects of right-wing rule in America. And of course, Trump was speaking then you had Attorney General Pam Bondi, who I guess she forgets she's the Attorney General for the United States. She really feels like she's a legal counsel.
Americans are finally getting what they voted for. No longer will we have rogue judges striking down President Trump's policies across the entire nation. No longer. Today, in the 6-3 opinion, Justice Barrett correctly holds that the district court lacks authority to enter nationwide or universal injunctions. These lawless injunctions gave relief to everyone in the world instead of the parties before the court. As the Supreme Court held today, they turned district courts into the imperial judiciary. Active liberal judges have used these injunctions to block virtually all of President Trump's policies. To put this in perspective, there are 94 federal judicial districts. 5 of those districts throughout this country held 35 of the nationwide injunctions. Think about that. 94 districts. And 35 out of the 40 opinions with nationwide injunctions came from 5 liberal districts in this country. No longer. No longer. These injunctions have blocked our policies from tariffs to military readiness to immigration to foreign affairs, fraud, abuse, and many other issues. The judges have tried to seize the executive branch's power, and they cannot do that. No longer. No longer. These injunctions have allowed district court judges to be emperors. They vetoed all of President Trump's power, and they cannot do that. This has been a bipartisan problem that has lasted 5 presidential terms, 5 different presidents, and it has ended today.
I literally cannot stand the sound of her voice.
Me either.
Cannot stand it. But here's the thing, Matt, that I think is important. They're going to do what the hell they want to do. The previous Attorney General was sorry as hell. And I'm going to keep saying this and saying it again. When you get power, you exercise it.
Well, first, let me give you good news that you may not know. I was trying to find the exact numbers, but Pam Bondi's brother ran for president of the D.C. bar.
Oh, got his ass dusted.
Demolished. I mean, just demolished. I don't even remember the percentage, but I think it was sub 10%. So there's one benefit, at least the D.C. lawyers were like, nah, we're not the ones. But yeah, I mean, you're right. And I think that's a lot of what we're seeing. I think the Supreme Court is taking the tack that allows it to get where it wants to go. This whole thing about the imperial, all this stuff is obviously histrionics. But the thing about this court or this president is you want to talk about bipartisan. From all of those presidents from the 5 administrations before, what was bipartisan is the Justice Department had a separation from the White House so that you didn't become the White House's in-house law firm. The White House has its own counsel. Pam Bondi is not supposed to be essentially his outside counsel. That's how DOJ is operating. And, whether you want to debate the merits of the nationwide injunctions, it goes back to the federalism issue I was talking about before. If you read the syllabus to this opinion, all they talk about is how nationwide injunctions in courts of equity were something that don't have an analog in 18th century England. But the reason I think that is stupid is because we're at the point where we don't live in 18th century England. The law has to change, and it necessarily has to evolve with time. And what I see the Republicans do in this conservative court is they hearken back to this crazy, Scalia-type textualism every time they want to get to the point that they want to get to, which is giving Donald Trump what he wants. They're just finding a vehicle to get to that destination, and that, I think, is intellectually dishonest, but I also think it's dishonest with what we are as a country. We are no longer a country of 50 little states, 50 little fiefdoms. No matter how much we try to convince ourselves of that, we live in a country that is a globalized nation now. And the legal fiction that we're going to keep acting as though that isn't reality is just not going to get us anywhere, and it's going to continue to divest us of rights, particularly when you live in a Texas or a South Carolina or somewhere that does not want you to have rights, when the people in power are just continuing to give rights to people who look like them and divest them from others. So, I mean, we have to get to the point where we're honest intellectually about the country we live in. And again, here's the reality. The folk who actually give a damn, they're going to have to go hard at the ballot box. And it's as simple as that, Eugene. They got to go hard. I mean, you're dealing with people who want to, I keep telling people, they want to lock in power for the next 100 years. This ain't no cute little exercise. This is real power.
Listen, Hillary tried to tell you, Kamala tried to tell you. You had a Secretary of State trying to tell you, you had the Vice President trying to tell you. And now for the second time around, people are realizing they both are right, and they're feeling the effects of it. We saw what Jefferson Beauregard did in 2017 when Trump took power and then the first term. We're now seeing what Pam Bondi's willing to do for Trump as Trump took power in the second term. And the thing is this, the midterms are still a year and a half away, which gives them a very long time to do a whole lot of damage. While people are out protesting Vice President Harris's rallies, and you had the protest in Dearborn and some other places, they were going to protest vote, and everybody's sitting back worried, but what is Sleepy Joe doing? What is Sleepy Joe doing? Well, Sleepy Joe made sure he confirmed as many judges as possible at both the appellate and district court level, because of situations that we all saw coming just like this. That's why we're seeing the institution itself being attacked. Pam Bondi just today filed a lawsuit against the entire Maryland federal judiciary because they don't like the rulings coming out of Maryland. I believe we're one of those 5 districts that she's pointing out and whatnot. But the thing is this: people have to vote like their lives depend on it, because their lives literally depend.
Absolutely. Michael, about 30 seconds before I go to break.
Well, seeing that display from Pam Bondi today is an absolute disgrace. And when you study the history of the U.S. Department of Justice, it was created in 1870 largely to enforce the new rights of black people, like voting rights. OK, so when you look at what they're doing today, this is what you get. And she's acting like Donald Trump's defense attorney as opposed to being the people's attorney. That's what the attorney general is supposed to be, the people's attorney.
Yeah, but she serves one person. All right.